Myself Pooja is a member of LJRF GetNet TDP program, and today I had been assigned to take a review class about the topic environmental impact assessment. And these are the contents of this presentation. I will be dealing with an introduction, aims and objective, history and development, and what are the stages, and what all are the process of environment impact assessment, and what is its importance, who all are the stakeholders of EIA 2006 amendment and draft EIA notification 2020, and some important cases and MCQs. Let us have a quick glance about the concept or its meaning and definitions. So, according to the understanding of a layman, the term environmental impact assessment is a gauging or estimation of the impact of any project, program, or policy may have on the surrounding environment during or after its implementation. So it is an estimation of an impact to the environment for environment during or after its implementation. That is what in its simplest form, environmental impact assessment is what meant. And it is considered as an effective tool to ensure sustainable development planning and minimize any irreversible or prolonged damage to the environment. The aim of conducting such assessments remains uniform globally. The methods and practices might differ due to different environmental legislation prevailing in other parts of the world. So, the aim of conducting this environmental impact assessment remains uniform. The aim remains uniform globally, though the methods and practice different in different parts of the world. Coming to the United Nations environmental programs, definition of environmental impact assessment, they defined it as a tool used to identify the environmental, social, and economic impacts of a project prior to decision making. It aims to predict environmental impacts at an early stage in project planning and design. Find ways and means to reduce adverse impact, shape projects to suit the local environment, and present the predictions and options to decision makers. So this environment impact assessment in India is statutorily backed by the Environment Protection Act 1986, and its place of origin can be found, or it is based on the precautionary principle. Coming to the next slide, it mentions the aims and objectives of environmental impact assessment. First point is project development. The use of environmental impact assessment in project development may be regarded as a way of avoiding environmental impacts by using EIA at as early stage as possible in the development. This is also a way of avoiding cost due to these impacts. So, for developing a project, EIA helps to reduce or helps to avoid the cost due to this environmental impact, environmental damage അല്ലെങ്കിൽ environmental impactലൂടെ impact പറ്റിയിട്ട് അതിലൂടെ ഉണ്ടാവുന്ന ചിലവുകൾ അത് അവോയ്ഡ് ചെയ്യാൻ this environmental impact assessment help ചെയ്യും എന്നുള്ളതാണ് first point. Coming to the second point, development control through license, permits, etc. Here the environmental impact assessment act as a tool for authorities to prevent adverse environmental impact from the proposed projects. Third aim, plan development. EIA is a tool for authorities in planning of resource. This EIA often is called strategic environmental assessment. Next is policy development. Another use of SEA, that is strategic environmental assessment, is in policy development where the consequences of a policy can be evaluated by a government. Coming to the next slide, it briefly explains the history of environmental impact assessment in India. The Indian experience with environmental impact assessment began over 20 years back. It started in 1976 to 77 when the Planning Commission asked the Department of Science and Technology to examine the river valley projects from an environmental angle. In 1994, environmental clearance from the central government was an administrative decision and lacked legislative support. On 27th January 1994, the then Union Ministry of Environment and Forest, under the Environmental Protection Act 1986, promulgated an environmental impact assessment notification, making environmental clearance mandatory for expansion or modernization of any activity or for setting up new projects listed in Schedule 1 of the notification. The Ministry of Environment, Forest and Climate Change notified new EIA legislation in September 2006. The notification makes it mandatory for various projects such as mining, thermal power plants, river valley infrastructure. In the sense, road infrastructure includes road, highway, ports, harbors, and airports, and industries including very small electroplating or foundry units to get environment clearance. So this notification makes it mandatory for various projects such as mining, etc., to get environmental clearance. Get environmental clearance became mandatory after this notification. However, unlike the EIA notification of 1994, the new legislation has put the onus of clearing projects on the state government depending on the size or capacity of the project. The environment impact assessment in India is statutorily backed by the Environment Protection Act, and it also contains various provisions on EIA methodology and process. This is a quick glance about the steps in the environmental impact assessment. First step is screening. It is actually the purpose of that stages raises a question: is an environmental impact assessment is necessary, or this stage answer the question: is an environmental impact assessment necessary? Second stage is scoping. Scoping includes what all should be there in this environment impact assessment study, or what all should be included in this study. And coming to the third stage, impact ID and prediction. What aspects of the project will cause impacts on the environment? Impact mitigation. How can the design be changed to reduce the predicted impacts? And reporting. What are the key issues to be taken into account by decision makers? Next is decision making. Do the benefits of the project, social and economic, outweigh the environmental costs? Monitoring and evaluation is the next stage, where the environmental impacts correctly predicted. Coming to the detailed process of this earlier mentioned stages, or process of the environmental impact assessment. That is, on screening, what all the process has been conducting. So under the first stage, screening, the project plan is screened for scale of investment, location, and type of development, and if the project needs statutory clearance or not. In the second stage, scoping, the project's potential impact, zone of impacts, mitigation possibilities, and need for monitoring. And in the third category, collection of baseline data. Baseline data is the environmental status of a study area. Next process is impact prediction. Positive and negative, reversible and irreversible, and temporary and permanent impacts need to be predicted, which presupposes a good understanding of the project by the assessment agency. Coming to the fifth process, mitigation measures and environmental impact assessment report. The EIA report should include the actions and steps for preventing, minimizing, or bypassing the impacts, or else the level of compensation for probable environmental damage or loss. Coming to the next process, that is public hearing. On the completion of EIA report, that is environmental impact assessment report, public and environmental groups living close to this project site may be informed and consulted. Next is decision making. On decision making, the impact assessment authority, along with the expert, consultant, the project in charge, along with the consultant, to take the final decision, keeping in mind environmental impact assessment and environment management plan. Next is monitoring and implementation of environmental management plan. The various phases of implementation of the project are properly monitored or not. That is what examined under this process. Ninth is assessment of alternatives, delineation of mitigation measures, and environmental impact assessment report. For every project, possible alternates should be identified and environmental attributes compared. Alternatives should cover both project location and process technologies. Risk assessment, inventory analysis, and hazard probability and index also form part of the EIA procedures. So what is the importance of this environmental impact assessment on environment? Okay, this environment impact assessment links environment with development for environmentally safe and sustainable development. It provides a cost-effective method to eliminate or minimize the adverse impact of developmental project. It enables the decision makers to analyze the effect of developmental activities on the environment well before the developmental project is implemented. It encourages the adaptation of mitigation strategies in the developmental plan. It makes sure that the development plan is environmentally sound and within the limits of the capacity of assimilation and regeneration of the ecosystem. Who all are the stakeholders of EIA? One is those who proposes the project. Second, the environmental consultant who prepare EIA on behalf of project proponents. Pollution control board, state or national. Public has the right to express their opinion. The impact assessment agency. And the last one is regional center of the MO, Ministry of Environment, Forest and Climate Change. Coming to the 2006 amendment to the EIA notification. What all are the changes? First one is a decentralization of project clearance. It classified the developmental projects into two categories. That is category A, national level appraisal. Projects are appraised by the impact assessment agency and the expert appraisal committee. And under this category B, the state level appraisal. Here, the state level environment impact assessment authority and state level expert appraisal committee provide clearance to the category B project. This amendment introduced different stages, and the amendment introduced 4 stages into the EIA cycle. It is in this amendment, this cycle has been introduced, that is screening, scoping, public hearing, and appraisal. Under this category A project, before previous slide, category A and B project had been mentioned, and category A projects require mandatory environmental clearance, and thus they do not have to undergo the screening process. In category B projects, they have to undergo a screening process, and these are again divided into B1 and B2. B1 had mandatorily required environmental impact assessment report, and B2 not requiring EIA. So coming to the features of this 2006 amendment, it decentralized the environmental clearance projects by categorizing the developmental projects into 2 categories, category A and category B. Category A projects are appraised at the national level by Impact Assessment Agency and the Expert Appraisal Committee, and category B projects are appraised at state level. After 2006 amendment, the EIA cycle comprises of 4 stages now: screening, scoping, public hearing, and appraisal. So this is the major change that has been brought into after 2006 amendment. Now let us have a quick glance to the draft EIA notification of 2020. The Ministry of Environment, Forest and Climate Change has published the draft Environment Impact Assessment Notification 2020 with the intention of replacing the existing EIA notification 2006 under the Environment Protection Act 1986. The key proposals of the 2020 draft include First one, reduced time for public hearings. One of the major steps of the EIA mechanism is the public participation. The 2020 draft proposes to reduce the notice period for public hearings from 30 days to 20 days. Next is it exempted the project, that is exemption of project. Furthermore, by classifying a number of projects into A, B1 and B2, a host of projects are being exempted from public scrutiny. Category B2 projects do not require mandatory environment clearance, unlike the category A and B1 project. Second is post-clearance compliance. It implies that once a project gets approved by the concerned authority, the proponent projects are required to adhere to certain rules laid down. Proponent projects are required to adhere to certain rules laid down in the EIA report in order to ensure that no further environmental damages take place. Next is annual submission of reports. The new draft EIA proposes the submission of compliance reports annually. Environmental experts are of the view that allowing a longer period for filing the compliance report will give an opportunity to project proponents to hide disastrous consequences which could go unnoticed. Another change that had been mentioned under the draft notification 2020 is no public reporting for non-compliance. That is, the EIA notification 2020 excludes reporting of violations and non-compliance by the public. Instead, the government will take cognizance of reports only from the violator, promoter, government authority, appraisal committee, or regulatory authority. Post facto clearance is the another change introduced. And this is a major proposal in the draft 2020, that is granting post facto clearance. That is, where a project that has been operating without environmental clearance can be regularized or allowed to apply for clearance. The judiciary has held, as in the case of Alembic Pharmaceutical versus Rohit Prajapati in April 2020, that environment law cannot countenance the notion of an ex post facto clearance. Penalty for firms. Firms found violating the terms of their establishment, if they have to get the clearance, however, will have to pay a penalty. These are the important cases. First one is LG Polymers India Private Limited versus Andhra Pradesh Pollution Control Board. It is on 19th May 2020. It is also called as Vizag gas leakage case. This has been mentioned under the LMS platform. Detailed. This case has been mentioned under the table of cases. And this is Electro Steels Limited versus Union of India on 9th December 2021. It is also called as Electro Steel Judgment. This is about the ex post facto clearance. Pahava Plastics Private Limited versus Dastak NGO 2022, SEC Online SC 362. It is decided on 25th March 2022. Coming to the important questions. State true or false, till 1994, environmental clearance from the central government was an administrative decision and lacked legislative support. This is the first sentence. And the second sentence, on 27th January 1994, the then Union Ministry of Environment and Forest, under the Environmental Protection Act 1986, promulgated an EIA notification making environmental clearance mandatory for expansion or modernization of any activity or for setting up new projects listed in the Schedule 1 of the notification. And the answer is, options are, option A, statement 1 is true, the statement 2 is false. Option B, statement 1 is false, statement 2 is true. C, both are true. D, none of the above. The answer is C, the both statements are true. Second question is, arrange the stages of EIA cycle in order. Public hearing, screening, scoping, appraisal. And the answer is first one, that is screening, scoping, public hearing, and appraisal. These are the correct stages. 2020 draft of EIA includes 6 stages. 6 is the answer. And third one, the 2020 draft EIA notification proposes an increase in the number of category of projects to 5. Options A 4, option B 5, C 6, D 8. And the answer is option B 5. Question number 4. EIAs commenced in the year options A 1960s, option B 1970s, option C 1990s, and D 2000s. The correct answer is option A 1960s. Fifth question is, the origin of EIA can be traced to which of the recognized and well-established principle of environmental jurisprudence in India as well as around the world? Answer is the precautionary principle. Thank you.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the composition of the